protect an idea or a book, but you can protect the words which you have written. Now, who owns the intellectual property right? You or your business usually own the intellectual property if you create something. Contracts with employees and some contractor should say who owns the intellectual property of anything they create for you. Protecting your intellectual property allows you to stop others using what you have created without your permission. So this is very, very important law. Change others for the right to use what you have created. The type of protection you need depends on what you have created. For example, inventions are protected by patents and artistic work by copyright. So I am going to speak on copyright. You can use more than one type of protection for the same product. For example, you can patent your product and register its name as a trademark. There are different types of intellectual property protection, and it would be better to know just within 1 minute, and that is the copyright. What is copyright? Original literary and written work like novels or content on websites. Original dramatic, musical and artistic works. Television, film, sound and music recordings. Computer software, illustration and paper. On this background, I want to give a new concept, that is Indian classical music, which is created by our very old gurus, or which are called as the maestros or the ustad. They are no more. But that is the creation of the Indian gurus. This classical music has evolved from Indian philosophy, culture and traditions, which have a rich heritage of more than 5,000 years. Indian classical music, vocal oblique instrumental, provides peace of mind to the individual and ultimately results into realization of God or ultimate truth. Many ragas, dadras, thumris, bandishis, etc. of Indian classical music have been created by our old Indian gurus or ustad and today recited or performed by various families, gharanas such as Gwalior, Kirana, Atroli, Jaipur, Agra and so on. Today Indian classical music is becoming more popular in the world and has attracted many followers, disciples across the globe. Now this universality of Indian classical music has created a crucial problem of copyright. Any non-Indian disciple, if modifies the original structure of raga, maybe from UK or maybe from United States, bandishis, etc., and creates a new composition and lays claim for international copyright of the same, then the right of the original creator, that is our Indian ustad or gurus, will to be in vain, and therefore the copyright of this Indian classical music must be with India only and not with any other foreign countries. For this I would like to refer the case for which the CSIR, that is the Council of Scientific and Industrial Research, has already fight at the international level or international court. That is the patent which was taken, which was given to the American scientists on turmeric, or that is a patent given on a rice variety known as basmati to the non-Indian scientist, a country from a country other than India. And very recently a patent given on the neem. Now, actually these are the plants which are found only in India, which grow very successfully, naturally, and they are found even in the wild form. And Indians, they know the use of these plants 5,000 years back, or the conception of the Indian civilization. That is, say for example, in turmeric antiseptic, say for example, neem antiseptic, and basmati rice, that is a fragrance, a flavor. But now if somebody actually studies this, a scientist from the other than India, and get patented, and then if the Indians stop the production or the cultivation of these plants, turmeric or rice, then how the scientist will go further, even though he has got the patent. And therefore the international court has given the stay to this and asked that the patent is actually given to those scientists, or patent is given to the land from where the plant is actually produced. The plant is originally actually cultivated. To that country only the patent will be given, not to the other country where the plant is not actually grown, but the scientist has actually studied, modified, developed the brand and patented. Now on the similar line, I am of the opinion that this Indian classical music or vocal music, which is becoming now very popular among the in the globe, across the globe, and they are modifying the composition and creating something new and asking for the copyright, then that should not be permitted. And that status which was given to the plant variety or a natural origin of the plant, the same status should be given to the Indian classical music or the vocal music. This is my a concept as a representative of Indian Council for Cultural Relations, New Delhi. Thank you very much.
Thank you, Dr. Pradhan. I think it was very interesting thoughts on your issue of Indian classical music and how copyright should be vested with the original authors, original creators. I think if we have any questions, we would probably either take it now or at the end. So we'll probably take it at the end of the session. So we'll now go on to the next speaker, Charlie, for her presentation.
Thank you. Good evening, greetings everybody. I'm very happy to be here today. My name is actually Seven. It's, well, you know, Charlie, but it's okay. I'm actually called Seven. I'm from the family of John Charles, and I've been graciously invited to speak here today by Dr. Adish Agarwala on protection of intellectual property rights, a subject I'm extremely passionate about, that is critically important for everybody to fully comprehend the scope of, because it's a field that's often underestimated in terms of the huge market value and the impact it has on all our lives in society, particularly when the vast proceeds of the wealth amassed from it get into the hands of the wrong people. I was invited to speak at short notice, and the subject area, as we all know, it's expansive. And I don't believe in the allotted time that I have, you know, I would be able to cover everything, but if I could, believe me, I would. I've made some notes, but I speak absolute truth, sincerely from my heart, on behalf of all creative people whose ingenious ideas, great achievements, and labours of love that have transformed the world without receiving credits, payments, and rewards and recognition. I also speak on behalf of all those whose lives have been cut short as a consequence of intellectual property organised crime, IP crime, which is actually known of. You can go to the government website on the IPO office, which is Intellectual Property Office, and you'll kind of get an overview of intellectual property organised crime. And my talk is with the view of protecting generations of future creative people and the public at large. I'm grateful to be given the opportunity to share my knowledge as a professional, independent creative innovator with 11 years legal experience, whose works, my own IP and creative works and achievements over the last 30 years also cover the fields of music, television, film, and the literary world. So I speak today from the perspective, not as my honourable friend said about celebrities, that's not really my area, although some of my work covers celebrity-based shows. I speak specifically from the perspective of an individual creative innovator and an IP owner, who's also a mother and a grandmother, with a deep respect for truth and all the laws handed to us by God, in particular our inalienable rights. In sharing the truth, I hope it will bring much insight, transparency, resolution, and healing for all those who have been adversely affected. And I pray it will be a loud wake-up call to inspire all who are paid to enforce rule of law, to recognise the need to implement immediate emergency measures to shut down all known IP crime members and their cartels, in protection of individuals, IP creators and owners with valuable works like myself, as well as the public. Now, there is a distinction between an IP creator and an IP owner. All IP creators, that is, are intellectual property creators, creative individuals, whether they're creating software, music, TV productions, movie scripts. They are the rightful copyright owners, whether it become patents, whether we're talking about trademarks. There's 4 categories. You've got copyright, as my honourable friend said, copyright, design and patent, and trademark. And the other category is the IP owner, which often is not the actual IP creator and rightful person who should be attributed the wealth amassed from its huge profits. So basically, this is my emphasis today. Alarm bells have been ringing about serious IP organised crime as far back, in the UK anyway, as far back as 2004. An investigative report done by Denise Roberts in the Voice newspaper in November 2004 pointed out there was a 19% rise in serious organised crime from the previous year, and that the growing trend had reached epidemic proportions in the UK, chiefly because it's far too easy to steal creative people's valuable works and put another identity to it. In the report, revealed in 2004, that over 1.9 million creative people worked within the creative sector, from casual workers, freelancers to part-time creative people. IP criminals have gotten used to free riding on creative people's valuable IP. Although they claim billions each year in illegal profits and revenue, they don't value the time, expenditure, labour and expertise and individual that goes into the creation of IP. Since 2004, these figures in the UK, and we're talking 10 years ago, have quadrupled and skyrocketed to staggering levels. And trillions of concealed assets, black market revenue, now funding other heinous forms of organised crime such as black ops, targeting of IP creators, gang stalking and domestic terrorism operations. Despite over 65 police reports from myself, letters to the UK Prime Minister, appeals for help to every virtually conceivable UK organisation and authority in the last 11 years, taking legal action myself in the British courts, Royal Courts of Justice, namely Chancery Division, against the well-known IP cartel, and them all being found guilty and winning my case against 10 corrupt individuals in 2006 with 14 witnesses. My case was concealed at the highest levels. Consequently, these power-crazed, psychopathic criminals are still operating organised IP crime uninterrupted with devastating consequences to the absolute detriment to the public at large. In addition, alarmingly, on account of their large-scale international racketeering operations, they have amassed vast wealth, power, influence, illegally with the full knowledge of UK law. Sorry, I'm sort of... This is a passionate subject for me, but I ask you all to hear me out. It's a bit of a speech, but